Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-1170, Rohan Ramsingh petitioner versus Transportation Security Administration. Mr. Corbett for the petitioner, Ms. Edwards for the respondent.
Good morning, counsel. We'll hear counsel for petitioner.
Good morning. May it please the court. My name is Jonathan Corbett on behalf of petitioner Rohan Ramsingh, and I wanted to elaborate on a hypothetical that I raised in our reply brief. Let's suppose you have the misfortune of severely breaking your forearm. I'm speaking of a compound fracture requiring a team of surgeons to spend hours reassembling little splinters of bone that make up your arm. They succeed and they put you in one of those fancy casts that latches shut, and the doctors warn, if you take off this cast before 2 months goes by, there's a good chance your arm won't heal properly and you will permanently lose some use of it. Then let's say you go to a TSA checkpoint a month later. They do some initial screening, and then they say, okay, we need you to open up your cast because our secret policies say that's what's required here. One of the questions before the court is absolutely this simple. Can TSA require you to open up that cast under penalty of a maximum fine of over $13,000? Or is a bona fide medical condition a defense to that fine? TSA argues they can order you to do as they please.
And what evidence do we have here of a bona fide medical condition that was presented to the TSA examiner?
Sure. So my client presented records from the U.S. Veterans Administration. He presented
to the examiner on the scene.
To the examiner on the scene, he didn't present documentary evidence, but he described his condition to the person on the scene.
So they came up with this alternative, and he objected to that as well, correct?
The problem was there was no alternative. So he has two.
I thought initially they wanted him to raise his arm, right? And then they said, "Well, we'll do, a human pat down."
Yeah, so he has two conditions that both resulted from his military service. The first is inability to lift his arms and hold them over his head, a physical injury. And the second is a mental health injury. He has PTSD relating to military sexual trauma.
And what evidence was presented of that?
To the screener or to the court?
To the screener, the person who is trying to carry out the search.
So my client simply told the screener of his condition. He doesn't carry around documentation from the VA of his disability or anything like that.
So then his reaction was, well, I can just leave.
Well, at that point, they were saying, sir, you have to go through with the search. You have to let us touch your genitals. And he presented them with the option of, okay, I don't want to fly today. I'll just leave the airport. Which
so on that last point about the genitals, I know you say that in your brief. That apparently never came up between the two people. Is that correct?
That's not correct. My client testified that he specifically asked the scope of the search that they were going to perform. And a TSA general pat down does include touching of the genital area using the screener's fingers.
So having alerted, then what was TSA to do?
So TSA had a lot of options available to it. TSA has a bunch of imaging devices, whether they're X-ray or otherwise. They have bomb sniffing dogs. They have law enforcement that could detain someone if there's reasonable suspicion. They could have transported him to a medical setting. They could have called a paramedic. There were a lot of different options. Or they could have simply said, sir, I can't let you pass today. Well,
that's where they ended up when he said, well, I'll just leave. Right. I mean, what I don't understand about this case is this an experienced pilot, right?
He's not a pilot, no.
Well, he's seeking to be able to fly, right?
No, ma'am. He was simply traveling.
That's a passenger at this point.
Correct.
He wasn't even a passenger. He was just going to pick up his children.
Well,
he wasn't even a passenger.
was coming to the airport for that purpose that Judge Millett said.
I believe that's correct. He had a gate pass to meet his children.
Right. So he said he could just leave. I don't understand in that situation what TSA was supposed to do. He knew, as we all know, that when you go to the airport these days, you're going to be searched. And certainly if you alert anything, you're probably going to be subjected to what I'll call is a thorough as opposed to a light touch if you object to going through the machine.
Well, I think my client had been through TSA many times before and hadn't been subject to the kind of search that was being proposed here. But because of whatever alert they said happened, they perhaps proposed a more intrusive search than he expected.
Wait, that's not accurate. The record is clear that he had been through a pat down once before.
Yes.
Pat down is one thing, but this
a pat down that triggered severe emotional responses.
Okay.
I'm okay. It's your record, right?
I mean, if
it's your client's story, it's your record. So I don't know why you're telling us that he hasn't been through a pat down like this before.
I don't recall the client ever saying that he had been through a pat down where they touched his genitals before. So if
well, he did, and they said that he broke down and cried, and it caused severe emotional trauma for quite some time.
Okay.
Can I ask you? You said that TSA had other options, like, I don't know, taking them into custody or whatever. You gave a list of 2 or 3, but not on that list was simply letting him go, right? I mean, this is a situation where maybe it's unfortunate, but he tries to go through screening and he triggers a preliminary alarm. It seems to me at that point, it's just very unrealistic to think that he has a right to just walk away.
Your Honor, we're not alleging that he has some kind of constitutional right to walk away. We're simply arguing that if he has a medical condition that would be triggered by what they're alleging that they would do, he doesn't have to go through with what they would do. If the TSA proposes something that would cause your arm to not heal if it was fractured, cause significant pain, whatever it is, they can't fine him for turning that down.
I'm sorry, is your challenge, you just said you agree that he couldn't walk away.
I'm agreeing.
So then what were they, if they can't do the pat down and he can't walk away, what were they supposed to do?
To be clear, I'm agreeing that there's no constitutional right to walk away. I'm not saying that that wasn't the best option. And in fact, that is what happened. Well,
you're here to make legal arguments, I assume, not policy arguments. And so what is your position if they couldn't or if you say he didn't have a constitutional right, I don't know what other kind of right he would have had to walk away. So he had no right to walk away. There's nothing you've pointed to us in TSA policy or statute that's given him a right to walk away. So what was supposed to happen?
Your Honor, unless there is a statute or regulation that forces him to remain, he does have a right to walk away. The question here is whether...
Where does that right come from if it doesn't come from a statute or regulation?
A right to move freely?
You just said there's no constitutional right, so I'm trying to figure out the source of this right to walk away. If it's not the Constitution and it's not in a statute or regulation.
What I'm trying to say is the TSA could have regulated against walking away, but so far has not. If there's no regulation that says he can't, then
no, but it's quite clear. They say that once you start screening, you have to finish it. That's pretty well settled. That's on the signs when you go in to a security checkpoint.
That doesn't make it law.
But it doesn't. Why does it make it unlawful? Unlawful for TSA to insist on finishing in circumstances where the initial pass-through gives them some cause for concern.
Well, if they had reasonable suspicion to detain him, that would have been one thing. They could have called law enforcement, but instead they charged him with interference. and he didn't interfere with anything. So
I
TSA
mean-
needs a charge here.
But your theory of non-interference seems to presuppose that he can just walk away.
Absent of regulation
When he-
that
When
he can.
he tries to walk away, if you assume that TSA at that point has to or can do something to finish the screening and make sure that the initial trigger was a false positive, he's interfering with their ability to do that if he insists on walking away at that point.
And my client certainly didn't walk away without permission. He asked them for permission to walk away and remained until a law enforcement officer escorted him out.
So what you say the refusal to undergo the pat down was not interference?
Correct. It wasn't interference because it was entirely passive. He didn't do anything to interfere, and because he had the defense of his medical condition.
You haven't raised a Rehabilitation Act claim, right?
No,
You haven't independently challenged the size of the fine?
it's not the size of the fine that's the issue here. No.
What is the issue?
The issue is that there's a fine at all, that one can be held liable for refusing to do something that might injure themselves.
If they have, let's just assume for these purposes that they have a right to require people to complete screening once they start it, and particularly once they alarm, as he did.
Is
Let's just
there
actually
no-
say, once they alarm, they have a, just take as given for this question. That there's an obligation to finish screening. Then I guess I'm still unclear what your view of is what should happen.
Is there no defense to this obligation, that a medical condition? What if one is paraplegic and they're asked to stand
That
up?
sounds like a Rehabilitation Act claim, which you just said you haven't raised.
We're bringing a simple defense to a civil penalty action. Your Honor, I see my time is at 3 minutes. Is it possible to reserve that for rebuttal?
Yes. Why don't we hear from the respondent?
Thank you, Your Honor, and may it please the court, Kyle Edwards on behalf of TSA. I think it's helpful to step back briefly for a moment to consider the full set of facts underlying the issuance of this particular civil penalty. Respondent regularly uses airports a minimum of 6 times per year by his own admission. He's previously undergone a pat-down search and did find it very emotionally disturbing due to his PTSD diagnosis. On the day in question, he voluntarily entered the TSA screening checkpoint. He tried to proceed through the AIT machine, through the walk-through metal detector, but the agent told him to go through the AIT screening machine. When he couldn't lift his arm due to one of his disabilities, the agent allowed him to proceed through the walk-through metal detector. And at that point, there was a swab performed of his hands to test for possible traces of explosives. That test returned positive. And it was at that point, after he had triggered that positive alarm, that Petitioner refused to complete the screening process and continued to refuse over the course of 30 minutes, requiring the involvement of multiple TSA agents, as well as eventually law enforcement officers. That refusal to complete screening plainly interfered with the screener's ability to perform their screening duties, because their duty at that point was to conduct a pat-down search of Petitioner. Now, Petitioner has said—
Does TSA have an accommodation for folks who, for reasons of disability, cannot endure a physical pat down, or at least of private areas? Is there any accommodation?
There is. So in this case, Petitioner was offered the chance to have the pat down in a private screening area by—
Okay, that's not an accommodation for people who can't endure it. Whether it happens in private or public, it's still the same physical consequence and emotional reaction and mental reaction. And so that's not an accommodation for the mental disability.
That's correct.
So is there an accommodation for the mental, if you cannot endure a pat down because of disability? And TSA, no, for purposes of this case, isn't disputing the seriousness of this disability.
That's correct. I mean, the answer—
Right, we're taking as given that he has a sincere and serious disability triggered by sexual abuse, sexual trauma. And he's not going to be the only person in the country in that situation. So what accommodation does TSA have for people who simply cannot, for physical or emotional, mental health reasons, be subjected to that type of groping and examination?
There is, I wouldn't describe it as groping, but there's no accommodation that would permit individuals to be exempt from the screening process. The procedure at the point where
not fully exempt. There's other, I'm not saying that they get a whole pad. Nobody wants anybody to have a pass on going through screening these days. But there are other ways of checking, are there not?
At this point, TSA's procedures were to require a pat down.
I'm just asking whether they don't have an accommodation.
There is not, and that is because Congress has required the screening of all passengers and property.
No, the accommodation is there's a distance. There's an alternative. This isn't binary, screen or not screen. So he couldn't lift his arms for the AIT, so it wouldn't get a good shot of his arms, but that was okay. You had the metal detector. Why couldn't he have gone through the AIT just to check the groin area?
So my understanding is that the procedure at this point was because he triggered that explosive trace detection test, and he'd gone through the walk-through metal detector already. The walk-through metal detector tests for metallic threat.
No, I'm talking about the other one, the AI, I think you call it the AIT, which
right.
I get it wouldn't have been a perfect screen because of the arm issue. But if the concern at this point, the only point we're talking about now, as I understand it, is the pat down stage and the mental trauma. And so, and taking the facts in the light most favorable to him, he says that he told them, I can do a pat down, except not in the groin area. Would the AIT, would running him through the AIT at that point to examine the groin area have been a reasonable accommodation?
That is not permitted under TSA's policies.
What's permitted under the whole point of accommodations is that sometimes the policy can't be followed, right? Sometimes the policy can't be followed. The policy at that airport was to go through the AIT, but he couldn't. So they accommodated him because he couldn't do his arms, lift his arms, or at least one arm. And so they accommodated him by going through the metal detector. I'm not asking what their written policy is. I'm asking what their accommodation plan was for individuals who, because of sexual trauma, couldn't endure a pat down.
And they do have accommodation policies. Petitioner could have brought medical documentation explaining his.
How would that have changed it?
It wouldn't.
If he had medical documentation that said, I have this military sexual trauma, what would have happened then?
It wouldn't have changed the fact that.
Then it doesn't matter. It wouldn't have changed how they treat him, right?
He would have still had to undergo the pat down.
Okay, so then what's the point of bringing the paperwork?
The paperwork can, in terms of just explaining to a TSA agent, can help.
That's not an accommodation. That's not an accommodation.
I understand that. The thing is that
it sounds to me like your answer is there's no accommodation, an alternative to pat downs.
There is not. Once you trigger the explosive trace detection test after you walk through the metal detector, the procedure is to receive a pat down, and that was offered to Petitioner in a private screening area. They attempted to accommodate.
I know, but I think we can agree that the location wasn't the issue. Of the screening was not the issue for this guy. When people have this type of trauma, that's not going to change anything.
Private screening does. I think that is an accommodation.
It may help other people. It may help other people in other situations. It's a good thing to offer for other reasons.
That's right. And I think here, I really do think that here the petitioner was offered accommodations. He was permitted to go through the walk-through metal detector because he could not raise his arm.
I'm just asking what accommodation he got for, he's got two disabilities. So take the metal detector and the arm disability off the table. That was accommodated. He was not accommodated or offered any accommodation for his sexual trauma.
Apart from the private screening, there was no other alternative.
Again, private screening doesn't address his trauma. When the trauma is to the touching. I mean, imagine if you had a child with on the spectrum, autism spectrum, and cannot be physically handled by other people without complete meltdown. Go ahead.
apologies, children with autism regularly go through the screening process, as do people with dementia and other issues. They are permitted, like Petitioner was offered here, to conduct that in private. They're permitted to have a—
No, my hypothetical is somewhat, is a child. There's all different reactions for all of these diseases. So a child comes in with all the documentation, cannot mentally, in a healthy way, handle being physically touched by strangers, and will have severe mental and emotional consequences if it happens. It'd be the exact same situation as this. Doing it in private wouldn't change that. I get that that's an accommodation for some people. It's not an accommodation for the situation here.
Now, why
The
isn't your
situation I'm
answer
hypothesizing.
simply that as a matter of policy, he can't be allowed to enter? That's it. If he can't be searched under these accommodations, then he can't go in, period.
That is absolutely the case.
That is too risky. I mean, I don't know why you're hesitating
No,
at just taking that position. I realize you don't want to lose a case, but all I'm saying is, why isn't that the agency's position, that Congress has vested in the agency, the security obligation? It has these alternatives available for people, but some people simply aren't going to be able to fly. And I'm thinking of people who, as a matter of personal choice, say it's just too traumatic for them to fly. So they drive everywhere, they take trains, or they don't go.
I'm sorry, Your Honor.
Take a ship or something, but they're not going to be allowed post 9/11 to fly on a plane.
Yes, that is our position, that there are certain people.
Has there been a Rehabilitation Act case that has challenged this, and that's been your position? Because that's a little shocking to me, actually, because with the Americans with Disabilities Act has an entire section on transportation and making that equally accessible to people with disabilities. And it should seem to me that while folks might not commonly want to go through this, if they have a situation like that, if the child's traveling for his grandparents' funeral in Hawaii, then there may be no other option for getting there. And it seems a rather harsh reaction to disabilities to say nothing else could be done, like a drug sniffing dog or a chemical sniffing dog.
It's the case here that if certain passengers cannot go through the process due to their disabilities or due to other reasons, they simply won't be able to fly. It is the case that Congress has required the screening of all passengers and property to ensure that there's no prohibited items that make it on board. TSA has been tasked with setting up regulations that—
I just want to be clear here. I understand what you're saying. And so that is, TSA has studied this issue about sexual trauma, or for other reasons, people can't endure a pat down, and has made the decision that there is no other way to accommodate them. They are not welcome to fly in the United States of America. Those disabilities are not able to fly.
They are of course welcome.
They're not welcome. They're not welcome because your theory is you get in line and then you have to agree to be traumatized.
It's so a couple of things. First, to the ADA point, there's no ADA claim here. That is something that Petitioner could bring. So that is a different case, I think.
No, I understand that, but I've been asking you about what the policy is, and you said to Judge Rogers, we've got a hard and fast policy, just don't fly. If you have this particular type of trauma, I'm assuming that we have studied this. We don't just reactively say there's no accommodation available. We've studied this and determined that we cannot provide any other accommodation.
So I think in thinking about this, it's also important to recognize that Petitioner regularly uses airports. He has been through a pat down before.
And he said he had severe trauma.
He did. And
point of deep depression, and even if he says we're taking it all as true at this point, to considering taking his life.
He did say that. And again, the point is he voluntarily entered that TSA checkpoint. That was his choice to do so, despite knowing that he would have to go through the screening process that is paramount to the protection of aviation safety.
The choice is that this isn't someone going on a vacation, right? You know, his children are coming to visit him. Parents have to pick up children. Airlines require that.
And in this
right?
particular circumstance, he
So
arrived.
what control did he have?
He arrived with his
Okay,
girlfriend.
but I'm assuming he's single and doesn't have someone else. How does he get his kids?
So
I mean, it's not-
TSA
I don't want to accept right up front that this was just a lightly made decision by him to go on a recreational trip somewhere. Sometimes people really have no choice but to go to the airport.
And TSA is not in charge of the handoff of unaccompanied minors. Petitioner could have reached out to the airline itself to discuss if it was possible for him to pick up his children without entering the screening process. In this case, as I noted, his partner came with him, and she was actually able to collect the children while he was still being refusing.
No, I'm just curious about TSA policy more generally, given the very bright lines both adopted in the TSA decision here and that you've been articulating, which seem to go much broader than the facts of this case.
Well, again, I don't think that the position is much broader than the facts of this case. Petitioner, the facts of the case are that Petitioner has previously been through this screening process. He knew that he might be subject to a pat-down search. He's gone through that before, and he did voluntarily enter the screening process. And so, it's very.
The TSA regulations recognize that there are defenses to a charge of interference, and I'm unclear what counts as a defense.
Sorry, can you repeat the first part of that question?
The regulation 49 CFR 1503.629 F4 recognizes that there are defenses to a charge of interference. Do you know what counts as a defense?
I do not.
Apparently disability does not, but
not.
Their theory seemed to think they're arguing that it is a defense. And you're telling me it's not a defense, but there are other defenses?
I'm not sure about that, Your Honor. Apologies.
Anything further?
I just want to stress the sort of importance of the government interest here. I mean, as the court noted in Akai from the Ninth Circuit, if people were able to enter the screening process, trigger a secondary screening due to possible traces of explosives, and then opt out of the screening process, that would allow potential terrorists multiple opportunities to attempt to penetrate airport security by opting out on the cusp of detection and then leaving the airport. And that is just.
What about the decision to fine somebody? How is that decision made? Does everybody that causes a kerfuffle at some level end up getting one of these civil penalties?
Go
ahead.
The civil penalty scheme. So what happens in a situation like this where law enforcement is called is that the law enforcement officers are the ones that decide whether to perform their own search of petitioner if they have reasonable suspicion, probable cause, and then decide whether to detain the person or let them go. The civil penalty scheme kicks in because TSA does not have the authority at the checkpoint to physically detain someone, the individual TSA agents. And so, there's an investigation that occurs after one of these incidents. There's the inspector's report in the record here, and a determination about whether to bring a civil penalty is made based on that investigation.
And so, I guess this is what I'm trying to ask. So, are you saying that every time police are called, then a civil penalty process? I get that the police are not TSA, that's separate. The TSA always pursues a fine?
I believe when law enforcement is involved, they always institute this investigation, and then the sort of whether the fine.
But do they always pursue a fine? Because I was just curious here about that, because I noticed he got a bigger fine than the guy who stripped down naked and required the shutdown of an entire checkpoint. He got a $500 fine. And yet the person who we are assuming for these purposes could not, because of disability, go through the pat down, got a larger fine. I'm just trying to understand how that happened.
Well, I think that the ALJ is capable of moving the fine amount. So here, TSA asked for the minimum amount, which I believe was in the range of $2,000 in terms of $2,000 in terms of the guidance for what a fine should be for non-physical interference, and the ALJ, taking into account petitioner's medical condition, actually reduced that to, I believe, $680. So that sort of determination is made on a case-by-case basis. I couldn't tell you sort of why the person who stripped naked in the Brennan case was $500 versus some other amount.
All right, why don't we hear from counsel for petitioner?
Thank you, Your Honor.
Thank you, Your Honor. So as opposing counsel has made clear, my client had two options and two options only. Option number one was to let them try and pat him down at the risk of whatever would have happened, whether he would have had a panic attack or whatever it is, or be escorted out of the checkpoint and face a fine. One of the problems here is that most of the times you go through a TSA checkpoint, you're not subject to a pat down. They're able to screen you using their machines and you go forward. So if you have a disability or some other reason that you can't be patted down, you can go through the airport 9 out of 10 times perhaps and not end up patted down. But that one time that you can't and you end up with the pat down, TSA wants to issue a fine with a maximum penalty of up to $13,000. So you off that with that choice of trying and you'll probably get through, but maybe you'll face a fine. It's not right. And TSA points to this idea that if they don't find people, then terrorists will get multiple attempts. Fines aren't dissuading terrorists. If you're set on bombing an airplane and you try once and you're rejected and go home, don't care if you're issued a fine. All this is doing is penalizing law-abiding citizens with disabilities who simply cannot complete the screening that TSA has demanded. And there is no opt-out, there is no alternative, there is no accommodation. Once they've decided a pat down is necessary, you either accept it or apparently you have to go through this whole process.
Okay, we'll take the case under advisement. Thank you very much, counsel.
Case number 21-7059, Fraternal Order of Police, Metropolitan Police Department Labor Committee, DC Police Union, Appellant versus District of Columbia and Muriel Bowser in her official capacity as Mayor of the District of Columbia. Mr. Conti for the appellant, Ms. Johnson for the appellees.
Morning, counsel. You may
Morning.
proceed. You may proceed.
Thank you, and may it please the court. Anthony Conti on behalf of the DC Police Union. The DC Police Union represents the rank and file members of the Metropolitan Police Department. And they became a politically disfavored and in fact demonized group in the spring and summer of 2020. And it wasn't because of anything that occurred in the District of Columbia. It wasn't because of anything that any DC Police Union member did. The DC Council recites as its impetus for the act that's being challenged and the portion of the act, something that occurred 1,000 miles away in Minnesota. The DC Council recites that there were peaceful protests, and that was another impetus. But there were also, in the context of when this statute was passed, many not so peaceful protests. This was a time when there were daily occurrences of riots in the streets. Shopkeepers were boarding up buildings in the district. Fires were being set. Officers were being attacked. Police stations were being attacked, and citizens as well. And not just in the District of Columbia, but many of the metropolitan areas throughout the country. This went on for months. And when it reached a fever pitch, the DC Council decided it needed to act on an emergency basis to quell what was occurring in its jurisdiction. It's important to note that we're not challenging every aspect of this act. We're challenging a very particular aspect that we view as punitive. The impetus of this act was because of a police brutality incident that occurred in Minnesota. And most of the provisions in the act relate to revisions to issues surrounding police brutality. There were changes to the Use of Force Review Board and its practices. The Citizen Complaint Board was revised. It involved more citizens. Body camera legislation was included that allowed for the release of body camera footage in these use of force incidents. And none of that is being challenged. What we're challenging is
just to be clear, and so what you're saying is that the legislation as a whole was not out to punish the police. It is just this one provision. This one provision that's driven by the animus that the asserted animus that you've referenced.
Yes, I mean, you could view all of the legislation as punitive, but that's not our challenge because you said you're not challenging it. You're not. That's correct.
I mean, you're not challenging it, or you don't think that it was?
We're not challenging it, and I think it.
So we're taking it as a given for this case that all the rest of the statute is not motivated by an impermissible animus, but you're focused on this, which you've described in your briefs as differential treatment with respect to collective bargaining on discipline measures.
Yes, because the test that the court's required to apply looks, to the reasonableness and the justification for it. And if it's believed that the basis for it was use of force abuses, then the reasonable justification is the regulating use of force.
I'm sorry, what claim are we talking about? Because I don't see the relevance of any of this for your equal protection process claims on rational basis review.
Agreed, and that's what I was getting to, Your Honor. I think it's the Bill of Attainder claim. When we get to the punitive nature, is what is really the focus and what draws in the enhanced scrutiny beyond what the court would normally apply, whether it's equal protection or due process. And in the Bill of Attainder analysis, the court looks to whether or not two components are met, specificity and punitive. And specificity is conceded and it was accepted by the lower court. But I think that is an important point that the court shouldn't gloss over. When a statute is deemed to specifically target a group like the DC Police Union, the courts have held that raises suspicion because it's singling out people. And under a Bill of Attainder analysis, that triggers that higher level of scrutiny. It's more exacting than rational basis because it demands that the purposes for the statute are not merely reasonable or rational, but non-punitive. The government has to do more than just assert a superficially non-punitive purpose. I think if the—
Can I ask, I'm sorry, I just need to clarify something though, to make sure I'm understanding this law. So the provision about no collective bargaining for disciplinary procedures is limited to MPD officers, correct? Right, that's your point, and not to other forms of police officers in the city, the Housing Authority Police, the Department of Corrections Police. Is that correct?
That's correct. That's correct.
Right. But other parts of this legislation, like the chokehold, say that they apply to law enforcement and special police officers. So like the neck restraint and this type of thing, does that apply to Department of Housing Authority officers and corrections officers? So it's just this provision about collective bargaining that's confined to Metropolitan Police officers?
Yes, I believe so, Your Honor.
I just don't know all the terminology. So are these Housing Authority police officers that you mentioned in your brief, are they considered law enforcement or are they special police officers? I just don't know what statute means by special police officers.
I believe special police officers are essentially the security police officers that police the different buildings within the District of Columbia.
Okay. So Department of Housing Police, are they normally encompassed within the phrase law enforcement?
I believe so, Your Honor.
Okay. All right, I wasn't clear on all this terminology. Okay.
Certainly, and also to be clear, when the DC Police Union is identified, which they are in the statute, that's not even all Metropolitan Police Department officers. The DC Police Union is rank and file, so it's the 3,500 or so officers, sergeants, and detectives.
Sorry, if you can just
Sorry,
go ahead,
Go
Greg. I'm sorry. I'm just getting confused about these categories. So in 116C1, it says all matters pertaining to the discipline of sworn law enforcement personnel shall be retained by management and not be negotiable. And then in C2 makes clear that that provision will apply to collective bargaining agreements with Metropolitan Police. And so what I'm trying to understand is C1, does law enforcement personnel just mean Metropolitan Police, or does C1, all matters pertaining to discipline of personnel shall be retained by management, apply to all law enforcement in the district, which would include, I thought you just said at least the housing authority police. And then 2 was just making clear that we're including in this collective bargaining agreements. And that's why I'm having trouble with the terminology in the statute, because it ties into your argument about targeting, at least for your equal protection claim.
Sure. And to be clear, the only police union or police officers that have been affected by the provision that excludes bargaining over discipline is the DC Police Union. It's not any of the other housing authority police or special police. With respect to, I think
do they have their own unions and they're not affected?
Yes.
Okay.
They have their own unions, yes, and they have their own collective bargaining agreements.
Okay.
And they remain unaffected by the legislation.
Okay. So when C1 talks about law enforcement personnel, at least there, that phrase law enforcement personnel seems to refer only to MPD and not all law enforcement personnel in DC, under DC jurisdiction.
Right, and I apologize, Your Honor, I haven't focused particularly on that, but I believe that was already in existence. That statement is a general statement of a management right, and that applies probably, frankly, to all unions and all district employees, that management retains certain generic rights relating to discipline.
Can I take you back to this question of punishment and animus? I mean, you're trying to reduce the bill of attainder question to, the extent to which this act was or wasn't motivated by concerns about the police and whether those concerns are justified, whether DC is overreacting. And I just don't really see why that's the case. The ultimate question is whether this act imposes punishment. And you can look to history and you can look to function. And what this act is all about is the scope of collective bargaining. And that seems very far removed from the heartland of punishment, which is a criminal sanction for something. So even if you think that the DC Council was wildly overreacting to one incident in a very different jurisdiction, I don't see how that comes close to supporting a conclusion that what they did was akin to punishment.
And Your Honor, I think as you stated it, if they just touched on collective bargaining rights, I might agree with you, but it wasn't collective bargaining rights. It's to eliminate collective bargaining over discipline. And so when you narrow your focus and sharpen your pencil to attack solely discipline, what you're communicating is that your belief is that there's something wrong that's preventing discipline. Even the district's articulation of the basis, which is the word accountability, not anything beyond more than that. accountability taken specifically in the context of solely removing disciplinary bargaining rights implies.
I mean, it's discipline in the administrative context, right?
Meaning how they go about administering discipline?
Yeah, meaning something other than criminal process, right?
Correct.
I mean, if you had one of these disciplinary proceedings and you raise an argument that this is effectively punishment and therefore criminal process attaches, you would lose that argument because it's not. It's nothing like criminal punishment that we're talking about.
Yeah, I agree. But I still think nonetheless, if the court looks at prior decisional law, yes, from the historical context, criminal punishment may have been the traditional Bill of Attainder analysis. But what the case law tells us is that the Bill of Attainder clause is not meant to be strictly interpreted from a historical context. I think if the court looks at, I would say there are two overarching themes that you can take from the Bill of Attainder cases. First is the component of reputational stain. This is an act that was passed, and the council members that passed the act stated explicitly that the DC Police Union was a racist organization that engaged in brutality, and that was the impetus for this act. From the standpoint of Bill of Attainder analysis, the court has to look at that reputational stain because that's precisely how they've taken an identified group and labeled them. And if the court looks at some of the cases and some of the decisions more recently in assessing whether or not this is a Bill of Attainder punishment versus a reasonable and responsible reaction of the government, the court should be guided by whether or not the actor, the DC Police Union, was specifically targeted for their actions. Did that trigger this legitimate legislative action? So, for example, Bell South. Well, Bell South was engaged in monopolistic behavior. And so the court upheld regulations that related to this anti-competitive behavior. Nixon was specifically involved and attracted the attention of the legislature through his actions relating to his documents and his records. Kaspersky was singled out specifically for the fact that it had close ties to Russia. It presented the legislature with a concern over security, and they removed the concern. Here, if we take from those cases that lens and that viewpoint, what the DC Council has done had no bearing. They reached a conclusion, they stained the individuals, and they targeted specifically discipline.
Can I ask a question about the purposes of your impairment contract clause claim? So the collective bargaining agreement, Article 12, talks about setting up a committee to establish procedures, and they were supposed to do it within 6 months or agree to an extension. And by the time this law was passed, we were way past that time period. And so I was confused as to what happened with that committee and its whole process for setting up procedures, or was there essentially a determination just to go with the procedures that are outlined in the collective bargaining agreement? Or I'm just trying to see what was interfered with here.
And it's a very good question, and it's one thing that I did want to touch on. The 6 month is not that's not a time limit to start the process. That's a time limit from when the committee has been formed. And so it's a little bit misleading when you look at 6 months and you say, well, we're well beyond 6 months. The fact of the matter is the committee was never formed. And the reason the committee was never formed, which I think is very telling, is that clearly the parties both believed that the status quo for the time being was acceptable. Now, what the district argues is, well, the legislature spoke and it's no longer acceptable, so they've terminated that clause. Well, that's a termination of an existing contractual right. And it's not one that's in perpetuity, which is the other fallback argument of the district, because that right can be exercised and triggered by either side. And once that process starts, the committee has to be formed. And once the committee forms, there's the 6-month time period and the mediation process and impasse. And
what record evidence is there as to the parties believe that the status quo was satisfactory for the time being?
There's none, Your Honor.
Right.
But to the extent that either the backdrop of it was they couldn't reach an agreement, and so they agreed to form a committee.
It was, yes, excuse me, go ahead.
And so the backdrop was when they were engaged in bargaining the predecessor contract that is still in existence today through the automatic renewals. They reached an agreement that this was something that they would form a committee on and continue to bargain. And neither party has began to formulate that committee. Neither party has initiated that process. You could say there's no evidence that they're pleased with the status quo, but one would assume that if either side thought that this needed to be changed, that there was such a problem in the District of Columbia with respect to this accountability issue, and that they needed to change and reformulate how discipline was going to occur, that one of the parties would have reached out and began that process, and they didn't.
Well, that's speculation, isn't it?
Well, it's not speculation that neither side.
I mean, for all kinds of different reasons, and you're more in touch with this than I am, but
Sure.
These types of things happen all the time. Committees are set up or authorized, for one reason or another, they never get started.
Agreed, Your Honor. That's absolutely.
I don't think that's helping your arguments here. That's all I'm trying to get at. Not that you could not make a case, but rather that it's following up on Judge Katsas's point.
I think it helps our argument because in the district's briefs, their position is while this right may have existed, once the legislature spoke, it terminated that right. And that's the essential issue in a contract clause challenge.
Right. That's a different issue, though. And I just want to be clear about that. That's all. You made a representation, and there's no evidence of that. Now, the legal argument that the district makes is different in terms of it may be deficient for other reasons. That's my only, what I just want to clarify.
Understood, Your Honor.
Wait, I have something else I'd like to clarify, though. And so under your understanding of what sort of transpired on the ground, what this intervening legislation took away was not in a process, but was in fact, it just interfered. You had an existing arrangements that I guess it seemed like status quo both parties had settled on with procedures for dealing with discipline. And then this new process by saying it'll be unilaterally, whatever management chooses, consistent with DC law and the Constitution. And so it's the change in procedures, in the discipline procedures that's been interfered with, because there was no exercised right to form a committee and negotiate discipline procedures. You had the procedures in the collective bargaining agreement, and that's what's been disrupted.
I think both were disrupted. We have Article 12, and it contains numerous provisions that relate to discipline and disciplinary procedures. Mm-hmm. That was terminated. But in addition, you could think of it as a one-time option, an option to start a committee process to renegotiate provisions that would then be in the next agreement.
Yeah, that's nowhere in the text of this provision, right? It doesn't sound like here are the procedures, and if either party wants to change things, here's a process they can trigger. They've agreed to form, they shall do these things. And you're saying it just never happened. So it sounds like both parties just sort of forewent that opportunity. It's not like some springing opportunity you can bring up at a later point. It's not written that way.
Well, it's written to say that unless and until they do, that the Article 12 will be included in each successor collective bargaining agreement.
It's not. I mean, there's all kinds of time limits, and then going to mediation if the committee process doesn't break down. It seems rather different. I mean, I take it. I take your word that you're describing sort of the on the ground reality between the parties. But it seems.
Well, with all due respect, I mean, that's what I'm trying to get at. I don't think that he has said there's no record evidence to support his position. All right. And I think that's important to be clear what we're dealing with here. It's talking about serious challenges here. And we need to be clear what he has presented to support that. And I thought that's what Judge Katsas was exploring in his questions.
I would just point the court to Section 2, which says the current Article 12, as set forth in the existing collective bargaining agreement, shall remain in full force and effect during the committee's deliberations and shall be incorporated into any successive collective bargaining agreement until committee reaches an agreement on changes.
Right. It's in full force and effect during their deliberations, but there's no during deliberations period. There's been no committee, so there's no deliberations.
Correct, but these collective bargaining agreements span 3 years. So to read this so narrowly to say it had to be exercised immediately, had to be completed within 6 months would give no meaning to that. That it was contemplated that status quo would remain until one exercises the right through this committee process. And while no one has exercised that right, there's nothing in here that says that right terminates.
Right. So at the time of this legislation, at least the Fraternal Order of Police had not invoked that right to process.
Correct. I'm over my time, but I'm more than happy to answer any questions.
Well, let us hear from the government. We'll come back to you on rebuttal.
Thank you.
Good morning. May it please the court. Holly Johnson for the District of Columbia. Any ambiguity in this carryover clause in our Section 2 of Article 12, any ambiguity means that this court should interpret the contract in favor of the government, because what FOP is trying to do with this contract is preclude the legislature from enacting new laws. And under Winstar, the Supreme Court's decision, anytime the contract clause threatens a new law, if there is a way to get out of that contract analysis by looking for ambiguity in the contract, that's what the courts should do, because they don't want contracts to threaten legislative freedom of action. Now, interestingly, FOP's counsel has just introduced a new ambiguity into this provision that I was unaware of, that the committee never even formed and never even began its deliberations. But this does tie into one of the ambiguities I raised in my brief, which is that there's a lot that is not known about this process, and whether it's not completed but not extended, and whether the parties jointly agreed to extend it. So I do think that's one.
Why it's not known by the district. I mean, you're one of the parties. You guys should know what happened or didn't happen.
I should clarify. My understanding of what happened, which is not in the record, is different from what Mr. Conti just presented. But since we're basing this on the complaint, I think that I hadn't even considered that as another kind of ambiguity that this court could rule upon. But I'd like to point out another ambiguity that I think is even cleaner and is a clear way for this court to dispose of the contract clause claim. And that is the fact that this carryover clause, which is the only clause that FOP is arguing was effective at the time that the law went into effect, is itself terminable under the renewal clause, under our Article 48, Section 4 of the collective bargaining agreement. And FOP doesn't talk about this in their reply brief, even though it was a main point of our brief. This renewal clause says that any party within 150 days of the expiration of the contract, any party can disavow, can terminate, or state intent to modify any part or any clause in the collective bargaining agreement. And if they do that, only the related articles or parts of articles shall be affected, and the unrelated articles or parts of the articles shall continue in full force.
I need your help on this 150-day counting thing, because it seems too complicated.
It is a little complicated.
It's a lot complicated, because if I've got this right, each of these bills, you've had a whole series of, until mid-2021, you had a whole series of 90-day bills, one after the other, none of which could provide 150 days notice because they were all only 90 days long. And so you don't get a bill enforcing this provision longer than 150 days until, May 2021. And
I'm taking a
May
moment.
2021 is not 150 days before October 2021, when I assume this contract renewed again. So you have, I don't understand your notice argument. You're going to have to explain to me, because I don't think a 90-day statute can give 150 days notice.
So I'm going to respond to that. I hope the court will bear with me for a moment, because this is not an argument that FOP raised at any point in this litigation.
Well, you've made it, and it's just a question of math. So I'm just, I hope you
No, I understand that. My understanding of temporary and emergency legislation is that as long as they do not lapse, they continue in full force, and that Section 116 should have provided ample written notice. But if this court is concerned about that, then
I want you to explain to me how someone has notice. When do they get notice? They don't have notice when the thing is enacted on day 90, on the first day.
Correct.
And so you're saying you're supposed to add up different statutes?
Our argument is that they had notice 150 days after Section 116 was first enacted in July of 2020. Because if nothing else, that was ample notice that the district was not going to continue and at least intended to modify. I mean, the notice. I'm sorry.
You're saying they had notice when?
Okay. So when Section 116 was enacted, which was in July of 2020, that provided written notice to FOP that the district intended to modify Article 12 and thus Section 2 of Article 12 of the collective bargaining agreement.
No, because it only lasted 90 days.
And yet still, that would be an intent that we're not necessarily going to proceed with that. I mean, it doesn't have to be an intent saying, absolutely no way will we agree to any of that. All it has to be is, frankly, a letter that says written notice of intent to modify. But I will also note that worst case scenario, MPD has given written notice in a letter to FOP describing an intent to modify. And that
was that letter in the record?
It is not, because FOP did not raise
in your brief.
But FOP did not raise this argument that temporary legislation could not provide notice.
No, you raised the argument that temporary legislation could.
Correct. And FOP,
this is on you, and that you're telling me you're not. Do you have authority? Do you have a case or anything that lets me know this? Because this seems a very strange concept of notice to me.
No, what I'm telling you is that the district made the argument that Section 116 provided notice. FOP said nothing.
But you didn't explain. You just said it, but you never in your brief. But you didn't ever elaborate on how it could.
Well,
given
it
this
never
90-day time period. It didn't occur to you that a 90-day statute doesn't provide 150 days notice?
No, it did not, because the statute then was renewed.
Okay, and well, certainly raised a question for me.
Well, okay, but FOP didn't raise it, and I certainly would have introduced this. I would have moved to supplement the record with the letter that MPD sent, but FOP did not respond to this argument, did not suggest that temporary legislation cannot provide ample notice, and worst case scenario, then we're dealing with needing 150 days notice before the next
okay, but I just want to clarify one more time, when you made this argument about 90-day statutes, and you said, well, there was a series of them, so I guess you're supposed to add them up or something like that. I'm still not sure how it works with this CBA renewal dates. There's no precedent you're aware of in case law or administrative decisions involving collective bargaining agreement interpretations as to that's how that works?
No, I mean, this is a
Okay.
very unusual situation. So no,
Yeah. Yeah,
our
very
argument is
unusual.
that the statute provides notice. But even so, FOP certainly understood the statute to be applying beyond the 90 days because the FOP understood. I mean, that's why FOP is challenging this law, because it understands that the law is meant to dispose of this right. But I don't want to belabor this point. There are other ambiguities that we already identified in Article 2, in Section 2 itself in Article 12. And beyond that, I'm happy to move on to substantial impairment if this court finds that there was some impairment, because I think that you could easily rule on the grounds that the district court ruled on, which was whether there was a substantial impairment to a contractual right. And FOP's argument.
Sorry, just to belabor it a little bit, but this hope is a simple question, which is what happens under DC law if there's emergency legislation enacted, 90 days pass, and then there's no subsequent legislative act. I had thought the emergency legislation just expires by its terms.
That's correct.
Okay.
Yes.
I think there was like a 3-day gap actually between the first two statutes.
But if so, I mean, if the gap matters, well, then the second statute still would have provided 150 days notice. And again, because there are other
there was
grounds,
a gap in there when there was no law affecting the collective bargaining agreement.
So-
It's pretty complicated.
I mean, this
Sorry, just had some
Is your notice theory, once they enact the first statute and maybe given the political climate or whatever, the union would think, gosh, there's a reasonable possibility this will be extended many
Yes.
times over.
Yes, exactly. The written notice requirement in the collective bargaining agreement doesn't specify how it has to be. It doesn't have to be any magic words. And plainly, FOP was aware of the fact that the DC government no longer intends to include discipline in the next collective bargaining agreement. But again, I'd love to move on to substantial impairment because I don't think there's so many different grounds on which this claim can be dismissed. Under substantial impairment, FOP argues that the practical and substantive rights that are impaired by the statute is, and they say this primarily in their amended complaint at Appendix 584, that without the collective bargaining on discipline, the district will be allowed to conduct arbitrary, retaliatory, and illegal discipline. But this is simply untrue as a matter of law, because the Comprehensive Merit Personnel Act amply protects the officers from all of those things. And in Fatut and El Paso, the Supreme Court repeatedly emphasizes that substantial impairment requires impairment of real world interests, not just the right to protect yourself in one certain forum or under one certain process. So I don't think they've shown an impairment on their individuals. And then FOP argues that the collective bargaining over discipline is what substantially induced it to enter into the contract. But for that claim, you really have to look at which clause it is that was impaired. And FOP has not alleged, and I don't think could reasonably or plausibly allege, that carryover clause, that little clause that says if the committee has not resolved this matter, we will include Article 12 in the next collective bargaining agreement, that induced them to enter into this.
No. I think I'm not sure that characterizes their argument. I think it is, that Comprehensive Personnel Act was already on the books, but we as a union thought it powerfully important to have a seat at the table in establishing discipline procedures. That's why we negotiated Article 12. And Article 12 wasn't just a series of different procedures. It was a right to be at the table and negotiate and have the spokesperson for the police officers be part of the decision-making process on what procedures are. That's what I think their substantial impairment argument is. And they know, I don't know, you all probably know better than me, for some reason that was quite important to them. There's an entire article on it, and it had this very unusual provision that the district agreed to, that not only will they get a seat at the table, but this is going to carry forward into every other agreement, which I should think is unusual. And doesn't that signify the importance of it?
Well,
you call it a little carry forward thing. That seems like a big deal.
Well, no, I have two responses to that. The right to be at the table for disciplinary processes is not a contractual right. That's the statutory right. The collective bargaining agreement does not create the right to collectively bargain over discipline. And so this procedure, this joint labor management provision.
Sorry, I'm confused by what you mean. There's Article 12 sets up a whole procedure for them to be at the table to establish procedures. Yes? No? That's what this committee was.
But the committee was created because there was a right to collectively bargain over discipline. It's not like the district granted a concession to collectively bargain over discipline. I apologize, just Katsas.
No, I'm sorry. I was interrupting you. The Article 12 goes beyond the protections, well beyond the protections that would apply just by statute.
It does in some respects, but in the most critical respect, FOP disputes that matters. So the district argues that arbitration has led to, or at least that the council could have been aware of studies. We're not asking you to judicially note the truth of these studies, but the existence of them. That the council could have been aware of studies that show that arbitrators reinstate somewhat like half of terminated police officers. But FOP is disputing that. The only argument FOP makes in favor of arbitration, why that matters, is that arbitrators are chosen by both sides, that they have a say in who the arbitrator is. But there's no allegation in the complaint that the sworn judges, the administrative law judges at the Office of Employee Appeals are biased, or that arbitration is the only way to satisfy these substantive rights.
Intensely factual dispute is what this sounds like to me that you're talking about now.
I don't
appropriate at this stage.
I don't think it is. I think that, and I will note that to the extent there are some facts at issue, and if this court is concerned about that, the parties have cross-moved for summary judgment. Neither party has filed a 56, I think it's D now, affidavit saying more discovery needs to be conducted. And MPD and the district need a ruling on this as soon as possible, because they cannot start applying this. Right now, we are voluntarily continuing to apply the procedures of the collective bargaining agreement because there is such a great risk of somebody getting reinstated on a technicality. So I think both parties have put forth everything that needs to be before this court. I see my time is running low, and I want to make a few more key points. The first is that if this court wanted to reach the question, if it found that there was unmistakable evidence, that there's no ambiguity in the contract, that the district agreed to continue this provision on to the next or even more collective bargaining agreements, that this court could then move on to rule on whether the impairment was justified. And we have presented ample argument that it is. I also want to refer this court in the question of whether there was an impairment to now Justice Breyer's decision in Amalgamated Transit. Even if this court were to take out of the equation the Article 48 argument regarding timely notice, the clause at issue in Amalgamated Transit is very similar to the carryover clause. Am
I remembering? I thought that was a clause which gave either party the right to project the provision forward into future agreements in perpetuity.
So it's similar to this one in that it says, it applies to the whole collective bargaining agreement. So it's not like this applying to just one article. But what the clause said in Amalgamated Transit is that the parties would continue to apply the provisions of the preceding collective bargaining agreement. And if there was a dispute, they could negotiate regarding that and proceed to mediation or arbitration, I believe, to resolve that.
The way Justice Breyer framed the issue before him was he thought he was talking about provisions of the contract that provide for indefinite or perpetual extension, right? And here, if I understand the mechanics of this one, this is not like that, because putting aside all of the questions about when the notice kicks in and whether the statute applies in year 0 or year 1, right? At some point, the district has the ability under this clause to say, no, we no longer want to continue Article 12. So it's not an in perpetuity provision. It's at most transitional.
So if FOP's interpretation is adopted, then FOP is essentially saying it continues in perpetuity until the parties finish arbitration over any ongoing dispute. And that is similar to amalgamated transit. It's not an exact match, but all that is needed is
right. But they, even on their interpretation, I don't think they have the ability to make Article 12 perpetual just by dragging their feet or, refusing to agree to any change, right? Because if you reach loggerheads, there's an arbitration provision, and then the arbitrator can resolve the issue, right?
Yeah, and this is how I was connecting it to amalgamated transit, because that was also true under amalgamated transit. If you had a dispute, you could take it to an arbitrator and that would resolve the dispute. And so I just think that it is similarly there's similar ambiguity. And amalgamated transit, Judge Breyer relied heavily there on the unmistakability doctrine. And what he said is actually, if there's an opportunity, if either party could just walk away from the contract altogether after it expired, even that was enough to create ambiguity. So I think that the cleanest way for this court to rule is to say that there's no way that it is unmistakable that in this contract that the district agreed to continue carrying on Article 12 in the future, regardless of all of these different possibilities, all these different ways it could be terminable. I think just the fact that it is terminable itself creates ambiguity, even if the district didn't actually succeed in terminating it in a timely manner. And maybe that resolves Judge Millett's concern regarding the temporary legislation. This is a terminable clause. It is not a perpetual binding. There's a question as to which is more binding, and that itself creates ambiguity. If this court is concerned about that, FOP has not satisfied the substantial impairment requirement. It has barely addressed it in its complaint, and the arguments that it has made in favor of substantial impairment really fall away once you look at the protections that are already available under the CMPA.
Can I ask him just a quick question on the equal protection claim and this? The Department of Housing Authority, which they contend has sort of the most analogous reach to MPD. Do you know how large Department of Housing Authority police force is? Is it much smaller or about the same size? We don't know that. Okay.
Oh, I'm sure it's not the same size. I'm sure it's nowhere near the same size, but I don't know the size of its force.
Okay. If we assume, and I know there's debates about this, but if we assume at this stage that they are in many ways very factually similar in their scope of their authority, tell me again what why is it okay to just pick MPD to be the one to start with? There's earlier, we get to be under inclusive and these types of things. Those usually follow after a reason is given. And so what is the reason for focusing on MPD? And in particular, I noticed that I'm not even sure how it all works, but the resolution, I guess, came along with or preceded this statute, identified 4 district residents who had been killed: Jeffrey Price, Daquan Young, Marquise Alston, and Terrence Sterling. Whatever the circumstances of those deaths, were those deaths at the hands of MPD or DHA officers?
I have not looked into that, and I do not know. I would assume that they're MPD, but it could have been DCHA. I'm not sure about that.
Well, I mean, the resolution says MPD has had its instances of police killings.
Well, then I would assume that the council knew what they were talking about. Again, that's not something that I looked into or researched, because I don't think it's fair to see this legislation as a response to 4 specific killings or 2 specific extrajurisdictional
That's not my
events.
point. My point is, I asked you, you don't just get to say we get to be under inclusive. You need to have a reason, not much of a reason, under rational basis review.
So-
the reason for treating the two differently, and I wasn't sure if, I noticed you hadn't pointed to these MPD deaths, what the council says were deaths of Black individuals at the hands of MPD as, one reason for starting there. And so I wasn't sure if you had a different rationale
So
for starting with MPD.
I listed a few in my brief for not including the housing authority. And I think the most critical one is that the housing authority has a different employer. It has a different agency that.
That doesn't seem like a very powerful argument for the district.
Well, when you're talking about a question, I'm sorry, I favor. I'm not sure if that's a flattering interpretation for the district, but it is definitely a big difference. They're an independent agency, and we're talking about
Independent
discipline.
as in they're not controlled by the council?
They're not controlled by the mayor. They are under the
No,
council.
but they're not controlled by the council. I mean, the council is the one that's legislating here.
But the council is not the one that negotiates the collective bargaining agreements. The council is the one that is enacting the laws, but the collective bargaining agreements for MPD are negotiated by the mayor's office. And there's a specific agency that does that. And so it's an entirely different agency. And that alone is enough to make it not similarly situated. And, the Supreme Court has said that equal protection does not require a choice between attacking every aspect of a problem or not attacking it at all. And this is a police reform statute that was focusing on MPD in particular when it came to this type of to the accountability. And if the court will bear with me, I think it's important to note that the statute has a lot of provisions that deal with things other than use of force and that are not applicable to the housing authority, which handles its own training and discipline. And
that's what I was. Can you answer the question that I was confused about when I asked Mr. Conti about, do the other provisions in here, at least neck restraints, maybe we'll just start with neck restraints. Do those apply to other law enforcement agencies, the district like the DHA? It says law enforcement and special police officer use of neck restraints is excessive.
I believe so. I mean, that's, again, a lot of these questions that are proper questions that you're asking here didn't come up in briefing. And so I haven't had a chance to confirm. But yes, I think neck restraints would definitely apply. But changes to the
body-worn camera.
I actually don't know whether the housing authority uses body-worn cameras. I don't know whether that applies. But the changes to the police complaints board, I think, is specific to MPD, and that includes police officers' failure to report violations of rules and regulations, not just use of force regulations, but all of those. It limits consent searches, and it expands
just for MPD or for all district. You don't know that answer.
I don't. I mean,
that's all right. That's all right. I was confused by the language in the statute and how that mapped out to the language in section 116, but I guess that's just the way it is.
And the place where I know the housing authority probably wouldn't fall under the comprehensive legislation would be the specific requirements for hiring police officers or for expanding continuing education for officers. Or, for example, requiring visible officer identification during demonstrations. I don't know that housing authority officials are ever around, or I don't know if they are involved in demonstrations. Well, the most important thing, though, with regard to equal protection is that no one disputes that improving police accountability, and FOP is not arguing that police accountability is perfect. Nobody disputes that improving it is a legitimate and important government interest. And what the council reasonably thought is that allowing management or the council to control the disciplinary process, rather than having FOP have a seat at the table and getting to dig in their heels and bring it to impasse anytime they don't like a change, that would improve accountability. And FOP concedes, and they say this in their amended complaint at Appendix 591, that holding one accountable is accomplished through punishment. So there is a close rational nexus here. The collective bargaining encumbers reform. Just the existence of the collective bargaining agreement itself at the time controlled all of the disciplinary actions. But even if the CBA was not in effect, like if there was no collective bargaining agreement in effect at the time, just the duty to bargain over disciplinary procedures hinders reform. And the council created, and it's one of the last provisions in this act, the Police Reform Commission, and charged it with studying police discipline and providing evidence-based recommendations for change. If collective bargaining still existed regarding discipline, then those evidence-based recommendations may never be brought to fruition. And that is the reason for the law. It is important, it is compelling, and it is certainly rational.
Anything further?
No.
Thank you.
Thank you.
All right. We'll hear from counsel for petitioner, appellant, sorry.
Thank you, Your Honor. One point I want to bring up, and it's on this notice issue. The collective bargaining agreement, as counsel just acknowledged, is not something that the council enters into. It's entered into between the Metropolitan Police Department and agency union. And so when it says the parties can provide notice of their intent to terminate a provision, that's not accomplished by the council, who's not a party, as counsel just conceded, passing emergency legislation. And that's not the practice between the parties. The parties provide notice to one another.
I thought counsel referred to a letter.
I'm not aware of the letter. I think counsel also said that's not in the record, so I don't know.
Because it wasn't raised in your brief, so there was no reason to put it in. But she said, had it been, then she would have moved to supplement the record with the letter. So why don't you focus on matters that are most important to your argument in responding to the court's questions and what was argued by appellee's counsel?
Sure. On the issue of substantial impairment of real world interest, Article 12, which is before the court, has a host of real world interests that are impacted by this legislation. And it's not just a disciplinary in nature, but it ties into the disciplinary provisions. The right to carry a weapon couldn't be a more important provision. And that right to carry a weapon while under disciplinary investigation is part of what is provided for in Article 12. It also has provisions that relate to the promotion of police officers while under disciplinary investigation. And it has, in addition, provisions directly impacting suspensions without pay. So to say that Article 12 has no substantial real world interest, I think ignores how broad this provision that's been rescinded by the Councils Act is. With respect to the amount.
Is it the case that right now on the ground, DC is proceeding under the pre-act system, correct? Pre-act disciplinary system.
That's correct. And so when counsel raises the argument that that's out of concern for what the court will do, that's not my understanding. I mean, there's a carryover provision. And so if a new collective bargaining agreement is not negotiated, the carryover provision means it remains in effect.
Well, but if you assume that the carryover provision is transitional in the sense I was discussing with your friend on the other side, rather than giving either side the right to continue Article 12 in perpetuity. It's a transitional provision, and we're now, however long we are from the enactment of the statute, it just doesn't seem like a huge deal. You know, you've been, whatever disciplinary proceedings have been going on under the old statute. You would have known from the beginning that Article 12 carries forward, but only for a limited amount of time. And that's effectively what's happened here.
Well, I mean, it is a huge deal in that what we bargained for was not a perpetual agreement, and you could look at it as transitional. But and I would agree with Your Honor that the carryover is transitional. But we have a right to exercise our option one time. That's not perpetual. But what that right is that when the parties are dissatisfied, they will bargain and renegotiate. Article 12. That right was terminated. It just was. Now, it's not a perpetual right. It's not the same as amalgamated. It's a one-time exercise of a right that by definition will be incorporated into the next collective bargaining agreement, and the council terminated that.
But when you're negotiating future collective bargaining agreements, you do so against the backdrop of existing law, which now includes the statute.
Presuming that the law is constitutional.
It's clearly constitutional as applied to future collective bargaining agreements. I mean, the only contract clause issue I'll just speak for myself, that's giving me a little bit of pause is just this wrinkle with you think it's more than that, but this Article 12 carryover issue. Mm-hmm. If you're focusing on future collective bargaining agreements entered into after the date of enactment of the statute, there's no impairment problem with those.
Well, I would argue that if you've created a contract that makes a promise not in perpetuity, but in the future for the next collective bargaining agreement, it has. I mean, that's the very nature. The council can say that we're just terminating it as to the next collective bargaining agreement, which is exactly what they said. They identified any collective bargaining agreement entered into after this date. But if we have a right to have a provision in that agreement, that has impaired that right.
Well, I mean, you have a right to have that provision continue only to the extent that negotiations about the successor agreement are ongoing. Correct? Shall be incorporated into the successor agreement until such time as the parties agree on revisions to Article 12.
But that's existing Article 12. So we have the right for the existing Article 12 to continue into the next negotiated agreement. That's separate and apart from the right to then reopen negotiations on Article 12 and through this committee process. So we have two rights here. One is for Article 12 to carry forward to the next agreement unless and until the parties exercise the right to hold the committee meetings. And then depending on when that falls, that could be this collective bargaining agreement, the next, the following. But then once that's triggered, that's a separate and independent right to have a committee process, bargain for, negotiate another Article 12 that will be incorporated into the next collective bargaining agreement.
All right.
I'm sorry, just one quick question. So the current law expires on April 16th of this year. They've all been temporary. Do you know if there's a new law that's extending that beyond April 16th?
I'm not aware, Your Honor.
All right. Anything further, counsel?
Nothing further. Thank you.
Thank you. We'll take the case under advisement.
Be right back. Excuse me.
Case number 21-5128. In re application of Los Angeles Times Communications LLC to unseal court records. Los Angeles Times Communications LLC appellant versus United States. Ms. Townsend for the appellant, Ms. Danello for the appellate.
All right, the court will allow 15 minutes for petitioner and then 10 minutes for the government, with petitioner having a right to reply. And then we will adjourn briefly to go into an ex parte session where the government will continue its argument. Counsel for petitioner may proceed.
Thank you. Good morning, Your Honors. May it please the court. The clearest path to the proper disposition of this appeal is the common law. The government does not dispute, nor could it, that the sealed search warrant application and related materials at issue here are judicial records and thus subject to a strong presumption of public access under the common law. Accordingly, in ruling on the Los Angeles Times motion to unseal those materials, the district court was required under this circuit's precedent to apply the 6-factor Hubbard test and maintain those materials under seal only if it concluded that sealing was necessary after considering all of the relevant facts and circumstances of this particular case, and after weighing the interests advanced by the parties in light of the public interest and the duty of the courts. The district court did not do so here. Rather than apply the Hubbard factors to determine whether the public's common law right to inspect these specific judicial records was overcome and whether redaction was feasible, the district court instead crafted a Brightline Rule holding that the public's common law right is always categorically overcome as to an entire class of judicial records, search warrant materials related to law enforcement investigations that have not been, quote, acknowledged by the government. This Brightline test, even if it were applicable on the facts here, which it is not, is wholly incompatible with the very fact-specific, non-categorical 6-factor Hubbard test, and it is irreconcilable with this court's decisions, including its recent 2020 decision in N. Ray Leopold that make clear that the Hubbard factors must be applied to ensure that courts fully account for all of the relevant private and public interests at stake. Simply put, the district courts were—
I just ask, I mean, it's just a little bit of an awkward conversation, of course, because I can't drill down into particulars and you don't know the particulars, so I apologize about that. But isn't it true at a fairly high level of generality that there is no tradition of openness with respect to investigatory materials investigating criminal investigations that are either ongoing or closed and did not result in the government filing any charges. To the contrary, there's pretty strong tradition that when the government doesn't release materials like that.
I think there is a strong tradition of access, Your Honor, particularly relevant to both the common law analysis and the First Amendment analysis to search warrant materials post-execution. And in fact, the government's brief acknowledges that most frequently, following execution of a warrant, not just the warrant and the return are unsealed and made public, but the search warrant application and supporting materials are as well. The fact or status, let's say, of a government's investigation, whether there is an ongoing investigation, whether the investigation is closed, other facts and circumstances that may be relevant don't go to whether or not the right of access applies in the first instance, but rather speak to whether or not and to what extent the right of access might be overcome in a particular case. And I think that's what the beauty, quite frankly, of the Hubbard test and why it served as this court's lodestar for decades. It takes into account the specific facts and circumstances of the case. It would take into account, or should have taken into account, for example, the strength of the privacy interests, any privacy interests asserted here in light of the fact that Senator Burr himself had acknowledged the investigation at many points in time publicly, had acknowledged the the fact of the search warrant connected to the investigation when he stepped down the following day from his chairmanship of the Senate Intelligence Committee. There was lots of information that should have come into play with respect to the district court's analysis of the 6 Hubbard factors that were just completely not addressed at all by the district court in her opinion. I'd like to point out, Your Honor, the fact that this appeal is the LA Times' first opportunity to argue that a categorical approach to sealing judicial records is clear legal error under this circuit's precedent, I think is an unfortunate result of the wholly sealed ex parte nature of the proceedings below. Not only did permitting the government to make all of its arguments, including purely legal arguments under seal, deprive the public of its right of access to the government's briefing, but it also deprived the LA Times of a fair opportunity to confront and counter the arguments made by the government. And as a result, it appears to have significantly distorted the outcome in the district court. Had the LA Times known, for example, that the government would argue to the district court that it was dispositive that DOJ had not, quote, publicly acknowledged its investigation into stock trades made by Senator Burr and Gerald Fouth, the senator's brother-in-law, who is himself a high-level federal government official, the LA Times could have and would have pointed out to the district court the fact that a DOJ spokesman had confirmed closure of that investigation to multiple news outlets. And it most certainly would have argued to the district court, as it has argued to this court, that as a legal matter, that is not the correct test to begin with. As I stated in response to Judge Katsas, your questions, the status of the investigation, whether or not charges have been filed, the extent of information in the public domain about the investigation, and the source of that information, including whether, as here, the targets of the investigation is a public official, has spoken publicly about the investigation. These are specific facts and circumstances that a district court considers and must consider when applying Hubbard.
And one of the questions I had is accepting your point about being disadvantaged because you didn't know specifically how the government was going to argue. You did know about the factors, and there was nothing to bar your client, as I understand it, from arguing beyond what it knew the government had argued in this case, if you understand what I'm trying to say. In other words, you knew about certain facts, not only regarding the senator, but other matters. And those matters could have been identified for the district court in terms of the Hubbard factors. No, or am I just misunderstanding what your position was before the district court?
And we did, Your Honor, when we moved to unseal those materials, cited the Hubbard test, pointed the district court to relevant facts. We were not aware at the time, and quite frankly, it's surprising that the government would take the position that this investigation that had been widely reported on by the media, that had been spoken about not just by Senator Burr, but by Senate Majority Leader McConnell, that this was a non-public investigation. We weren't anticipating a situation where the entire proceedings, including every piece of the government's argument below, would be sealed and that we would have no opportunity to respond to that.
In fairness to you and your client, you knew the factors were there, and you knew that the district court had to address them. And to make your strongest case, why wouldn't you have just put forth for the district court in anticipation that the government either might make certain arguments or not point out certain matters? I'm just not clear about that. I understand, obviously, in these ex parte proceedings, you're at a disadvantage. But here where you're coming in, and I understand your point about the common law right of access, and you have to overcome the presumption. But given the question Judge Katsas asked you about, isn't it generally understood how these closed investigations or ongoing investigations into the possibility of criminal conduct are handled at the department? I'm just not clear about that. In other words, may not have anything to do with how this case is resolved, but I just wanted to understand in my own mind that while you may have come in thinking you had a clear right, nevertheless, you had to anticipate that maybe the government would take a different position, and for reasons perhaps that Judge Katsas's question signaled.
And we did, Your Honor, make a showing below with respect to our understanding based on the public statements made by Senator Burr, based on confirmation by DOJ spokesman that the Department of Justice investigation at least was closed. We certainly understand, based on the most recent disclosures made by the SEC in October, that the SEC has an ongoing, or at least did as of October, have ongoing investigations, insider trading investigations into Senator Burr's trades, into Mr. Fouth's trades. To the extent that
I have some experience working with the media, and the media doesn't take things at face value and has all kinds of contacts within the departments. And I'm just surprised that some of these matters weren't pursued, although I can understand why a prosecutor might have not cooperated in any way with answering your questions.
Well, at the time that the district court entered its ruling, Department of, though it was not a named DOJ spokesperson, multiple news outlets reported that the DOJ had confirmed that the investigation was closed. We now, again, know from more recent SEC public filings that the investigation, Department of Justice also confirmed to Mr. Fouth that its investigation into his trades were closed as well. That's information that he disclosed on the public docket. I think the salient point, Your Honor, is that even though, and I understand that you are limited in the way that you can ask me questions, and I'm somewhat therefore limited in the way that I can respond. But I think the salient point is that even in a situation like perhaps this situation where the district court is required to redact certain facts that it might deem relevant to an unsealing motion, that doesn't relieve the district court of its obligation to apply each of the Hubbard factors. And to speak to the specific
questions, excuse me, counsel, but my questions are premised on the notion that litigants often don't assume that the other party is going to make its arguments. And in this situation, Your Honor, I think the LA Times motion to unseal cited the Hubbard factors, indicated that the right was not overcome, particularly where here is pointing to the specific privacy interests that might be implicated here, that with respect to Senator Burr, that he had publicly acknowledged the investigation. This is a situation involving warrant targeting a sitting United States senator. The public interest was particularly strong. Those arguments were made to the district court. I think what the LA Times was not anticipating and could not have anticipated, quite frankly, based on this circuit's precedent and the way that the Hubbard factors are typically applied, is that the government would presumably argue for, and the district court would apply a bright line test that ignored those facts. No, I understand, but was the argument presented to the district court, for example, that once Senator Burr had publicly stated that the investigation, he had received notice that the investigation was closed, that while that didn't tell anyone anything about the extent of the investigation, still, wasn't that an acknowledgement that there was an investigation? That's all I'm trying to get at here.
We framed it within the context, and I would frame it, Your Honor, within the context of the Hubbard factors. The fact that Senator Burr was upfront about and public about the existence of the investigation indicates a diminished privacy interest, and in not disclosing. And I think this goes to the heart of precisely what's frankly wrong with the district court's ruling, which is that the district court, for example, took into account potential stigma to Senator Burr and perhaps Mr. Fouth as well of being associated with this investigation when that cat was well out of the bag. And that shouldn't have been a factor, therefore, in considering whether or not the common law presumption was overcome in this particular case. And note, Your Honors, I realize I have just a few.
Just one thing. Sorry, the history with respect to search warrants is that relevant to determine whether these are common law judicial records or only for your First Amendment claim?
The tradition of public access is relevant to the First Amendment claim, Your Honor. This circuit's precedent looks, with respect to application of the common law, to whether or not the records are judicial records. They're judicial records based on the role they play in the adjudicatory process. So I don't think there's any question that these are judicial records, regardless.
How would history at all, if at all, factor into the Hubbard factors, other than maybe privacy interests, or do we have precedent factoring history of access into the Hubbard factors? I don't mean to mix categories here, but I'm trying to sort of figure out how that might bear on anything. Or is it simply that you might have overlapping privacy arguments in the two contexts?
I think there may be overlapping arguments. I don't mean to suggest that the status of the government's investigation is irrelevant, for example, to the Hubbard analysis, to the strength of the property and privacy interests that might be implicated, which can include government law enforcement interests, for example. So it isn't as though that's an irrelevant factor, but I think it's built into the Hubbard test with respect to under the common law. And I think here, particularly given the more recent disclosures by the SEC, which I think also not only call into question the need for sealing, but I think call into question, quite frankly, the information that's been provided to this court by the government, the information that was provided to the district court by the government below, what representations were made, if any, about the SEC's claimed need for continued secrecy, when it appears that the SEC has not claimed any law enforcement need at all whatsoever for continued secrecy in more recent filings that it has made in the Southern District of New York. So I think particularly in light of those more recent facts, all of that, Your Honor, goes into the hopper, let's say, of the Hubbard analysis. It's all part of the specific facts and circumstances that court should look at when determining whether and to what extent the right is overcome.
Well, the SEC disclosure wasn't before the district court. So is that something we would apply here on our own, or would we have to remand for the district court to do that?
So I think I would say those disclosures are relevant for I'd make 3 points there, Your Honor. I think one, this court has its own independent obligation to determine the appropriateness of maintaining its own records under seal, which includes the redacted portions of the government's brief that we have moved to unseal. That motion's pending before Your Honors. The appendix, which consists of the records below, as well as, after today, the transcript of the ex parte portion of oral argument, which we would also ask be unsealed to the greatest extent possible. So this court has an independent obligation. Obviously, the current state of information in the public domain is relevant to this court's determination. More directly to your question, no, Your Honor, with respect to the record that was before the district court, the additional further acknowledgements that have now been made by the SEC were not before the district court at the same time. As we argued in our opening brief, before we even saw those additional disclosures, the district court failed to apply the Hubbard test, which is an error of law. There were key facts that were not applied. And so I don't think, with respect to remand, that it's an either or, all or nothing response. I think our position is that the court should reverse. There are likely pieces of information that this court will determine, particularly now in light of the SEC's disclosures, cannot and should not remain under seal. We would take the position that those materials should be unsealed, or that information should be unsealed immediately. To the extent there are closer questions, we recognize that it's this court's practice to remand to the district court to apply the Hubbard factors in the first instance. So I think that sort of hybrid approach would be appropriate here, Your Honor.
All right, anything further? Thank you. Let us hear from the government.
May it please the court. Elizabeth Dinello for the United States. The district court did not err in denying the motions to unseal. Before I go any farther, let me just note that for the purpose of convenience at this oral argument, I will refer to the alleged search warrant as the search warrant. That is not intended as a public acknowledgement of the existence of the search warrant. And like appellant, I will focus on the district court's ruling under the common law, what this court has called the broader but weaker right of access. The district court here was well aware of the presumption of access. It knew that the target of the search warrant was a sitting United States senator, and it acknowledged appellant's argument that there was a particularly strong public interest in disclosure. But based on the full record, the court found that compelling individual privacy and government interests outweighed the public's interest in disclosure. That was a proper balancing under Hubbard, and the court.
Can you point me? Can you point me in the district using the public opinion, of course, where the discussion section by the district court you say is, where do you find that court factoring in the presumption in favor of disclosure and the arguments in favor of disclosure, or addressing the arguments of public interest in disclosure raised by LA Times?
The court first.
Which page?
The court first referenced at page 5 of the court's
That's the
opinion.
background. That's the background section. I'd like to know where in the analysis of the. So that's why I said in the discussion section, which starts on page 10.
Well, let me just go straight to the conclusion on page 9, where the court finds that assuming that these materials exist, that various privacy and government interest in the contents of the search warrant materials would outweigh the public's interest in disclosure. That's summarized right there.
That's the end of the balancing analysis, but I don't see any actual discussion, or there's no acknowledgement in the analysis section here of the presumption of the arguments. I mean, it's just described as like a generic public interest in disclosure. There's no discussion of public status, what the nature of a privacy interest is or isn't. I mean, it's really pretty, it's all it seems to talk about is, nature of privacy interest from the public interest perspective, obviously. There's other references.
The court here, to start, Your Honor, district court, as in any case, is presumed to know and apply the law. The court here was obviously well aware of the law in Hubbard, which it laid out. It had obviously dealt with before.
You've got pretty clear precedent that even when you say the test, but if your application doesn't reflect the test, just saying the test up front, but when you get to the actual application, we can't discern it. Very smart judge, no doubt, knows what the law is, but in the analysis section, I think you're having trouble as well as me. All you've got in her analysis section is would outweigh the public's interest in disclosure.
Well, the court a number of times uses outweigh, override, indicating that it is doing a balancing. Furthermore, nothing in either Hubbard or any of the cases that follow require a judge to do a factor by factor analysis. Indeed, we're not aware of any authority that where there's a judicially created multi-factor test, a judge has to explain.
Well, we've been pretty clear that this is a case-by-case, the Hubbard test is a case-by-case record-specific application. And so the problem here isn't that, the district court didn't sort of, number them and go through them with little headings or anything like that. I think as your answer just pointed out to me is we can't even find a sentence in the analysis section acknowledging or discussing the public interest in favor of disclosure.
But the whole
That's more than just a technical argument that they didn't sort of march through every little thing.
But the whole point of this litigation was the appellant's argument that there was this heightened public interest and needed disclosure. The district court, in its opinion, in its public opinion, was in a difficult position because it was being asked to assess and explain to the public and to appellant why it was denying these motions to unseal without revealing whether in fact.
How would discussing the public interest, acknowledging the public interests in disclosure, right? They've been able to articulate public interests in disclosure
because they are assuming that the search, that is premised on their argument that the search warrant exists. If the district court here had focused on the particular interests, it would have necessarily revealed that there had been a search warrant of the phone of Senator Burr.
The district court did a pretty fine job of assuming things and arguing that way, as you've been doing here. So,
right, and my point is that here it was a given coming in. The court had obviously read the pleadings. It quoted at page 7 the appellant's argument that there was a particularly strong public interest at stake. It was aware of appellant's arguments in the pleadings that there was a heightened public interest, that the public and the media needed access to these materials in order to scrutinize the grounds for the search warrant. So here, the whole context of the litigation is this argument that there's a heightened public interest. And so when the district court, in its opinion,
not just a heightened public interest, a presumption in favor, assuming these records exist, there's a presumption in favor of their disclosure. It's judicial records. I'm not talking about First Amendment claim here. I'm talking about the common law one. There's a presumption in favor of disclosure.
And here, Your Honor,
not just a heightened public interest. There's a presumption, and that presumption gets us to an already skewed balance, which we also have to pile on the public interest. If assuming these documents exist, what is the public interest?
Again, the district court here is presumed to know and apply the law correctly. And there's nothing to indicate that the court here didn't understand the law. And if I may, Your Honor, just move on because I see already I'm running short on time. Just want to respond to a couple points of appellant. The court here did not.
Can I just press you a little more on that? I suspect we'll give you time to make your points, but I mean, you're right. The government, the district court could not put on the public record whatever interests, if any, would cut in favor of maintaining confidentiality, if any, right? But on the other side of the balance, you're talking about activities of a sitting senator. You're talking about allegations of insider trading, which is by members of Congress, which is currently very much in the public discourse. And there's district court can talk about all of that, and there's not even a sentence about it and there are no confidentiality limits on the district court's ability to acknowledge that. Those on that side of the balance talk about those considerations and weigh them.
Well, if the question is whether the court could have written its opinion in a different way, yes, it could have.
I mean, I guess
whether the court didn't, whether the court is concerned that the district court didn't know and apply the law correctly, there's no indication here that the court did not. In fact, the court's reference to the particularly strong interest indicates that the court was sensitive to the heightened public interest in this case. the opinion is what it is.
Where in the privacy and now there's just discussion, obviously generically, about privacy interests and closed investigations. Assuming there was such a thing here, just like you will just assume it for the purpose of this point. Where is there any discussion or recognition of diminished privacy interests when someone's a public official? Conduct involves their performance of public duties. This isn't a case. We've had other cases about even if you're a public official, something very private going on in your life. That's not this case, as it's brought to us. And it's at least as the LA Times has laid out, there's plenty of, well, it's not just plenty of reporting. You have Senator Burr on the record talking about this matter, certainly when he says it was closed. And Mitch McConnell talking about an investigation. And so where did the district court factor that in to the discussion of the privacy problem?
The short answer is the district court did not express that.
The district court impliedly addressed
how Senator Burr's position might factor in. But with respect to the...
So it didn't address that aspect of privacy, it only addressed one side of the privacy arguments in this case.
Right, but the court also recognized, this goes to your question about Senator Burr's public announcement, that the court recognized there's a second distinct privacy interest by a target, and that is in the contents of the investigative materials. And whereas here you have...
I'm not getting that. I agree the district court talked about privacy on one side here, but you just agreed with me. District court didn't even talk about privacy, the other side of the privacy balance here.
No, I think we are reading the court's opinion correctly. The court didn't mention that. But what I'm suggesting, Your Honor, is that the court nonetheless is presumed to have understood these interests and appropriately recognized the countervailing interests on the other side. I did just want to follow up, though, on your point about
go ahead. Sorry, go ahead.
About Senator Burr's acknowledgement of the investigation and respond to Ms. Townsend's point that he also acknowledged the search warrant. He did not. He never said anything about the existence of the search warrant, nor has the Department of Justice, nor has the SEC. The only basis for the media reports is that unauthorized disclosure by the unnamed law enforcement official.
Well, he did say the FBI came to visit. I'm giving you a quote here of what he said.
There are plenty of reasons that the FBI can come visit, including coming and asking for consent to search. That certainly doesn't disclose the fact of a search warrant.
Sure.
Nor, as the district court pointed out, he still has a privacy interest in the contents of the materials, and there are potentially privacy interests.
But then there's countervailing arguments as to, and speaking all hypothetically here,
but
countervailing privacy concerns or reduced privacy concerns that aren't discussed. Where did the district court had a brief line about the fact that there'd been public reporting? Didn't seem to matter. I forget the exact these are on page, it's Joint Appendix 12. These interests are no less great where some of the relevant information has been reported on in the news media. On the other hand, we have cases that have found, we have case after case that has found extensive media coverage very relevant under the Hubbard factors. Well, so how does this opinion address that aspect of Hubbard under our case law? How does it put weight on that? Where does it put weight on that?
Well, again, you're asking me where in the opinion that we're both reading at the same time, Your Honor. what the court did recognize was that there had been no acknowledgement by the government of the search warrant or any disclosure of the contents of the materials. So regardless whether there was common knowledge of the investigation, Member Hubbard, too, at page 318, when it talks about the public access factor, talks about access through legitimate public channels.
There are a lot of news articles, news reports about a supposed search warrant as well. A lot.
Right, but they all derive from the same source.
No. Many of them named their own sources.
All right, well,
A variety of sources in the articulations that I've read.
But again,
I think what we're pressing you on is the government's position that the district court adequately considers the Hubbard analysis by reciting the factors and adding a conclusory statement about the ultimate analysis by the district court. Because contrary to a statement I thought you made earlier, and maybe I misunderstood what you said, we have remanded a number of cases to the district court to complete a Hubbard analysis. And simply reciting the factors is not enough. Simply the presumption that the district court applies the law correctly is not enough. And I realize these are very fact specific.
Yeah.
But your statements here and in your brief seem to be close to saying, if you acknowledge you know about the test, if you recite the factors so we know you're aware of the factors, and you have a conclusory statement, that's enough. And yet I think our circuit president has strongly indicated that's not enough. Wouldn't you agree?
The district court did not simply recite the factors and then have a conclusory statement at the end.
Well, what I'm getting at is
Katsas
and Judge Millett's questions have honed in on the fact that we don't have an analysis as such.
The district court, well, first, let me just back up and
Sure,
say
sorry.
that where the court has remanded, it's because either the district court, as in Leopold, added a factor that was not relevant to the Hubbard test, or more typically, the district court has not applied Hubbard at all. Here, the district court did engage in a balancing, as evidenced by its use of words like override and outweigh. The district court simply didn't go into the level of detail that the court is suggesting was required.
Why
But
wouldn't it
again-
be
but again,
appropriate,
as long as-
Mrs. Donnell, because you're a very experienced prosecutor here. Why wouldn't it be preferable to have the court deal in some detail with these factors so that at least by the time the case comes to appeal, if it comes to appeal, we don't have the situation that we have now, where we can't find things, we don't see things. And given that there is a presumption here, wouldn't that be a more appropriate way for the district court to proceed? That's all I'm trying to understand. And I don't quite understand the government's argument. And I realize you're hindered in responding, but
at this point where the case is on appeal, and the question is whether the district court abused its discretion in its application of the Hubbard test. The district court did not err as a matter of law because the opinion reflects that it did apply the Hubbard test and did do a balancing. So what it comes down to are two problems that I'm hearing articulated. One is that the court didn't express in more detail how it was weighing the factors. And certainly that would have been helpful. But was that an abuse of discretion? We suggest not.
Well,
And
just to
so
correct,
what-
just, I'm sorry. In any detail, it's not a question of more detail, in any detail at all. And so that's the way in which we have to ask the abuse of discretion standard. So if you could answer in any detail, not in more detail, that's a very different abuse of discretion question.
Well, the district court did recognize, and admittedly in a cursory manner, the particularly strong public interest in access. So it wasn't as if the court ignored that factor altogether. But taking your point, Judge Millett, even if it's any detail, the district court here was not required to weigh the particular factor. As in say, when a judge is analyzing sentencing factors under 1353A, a judge is not required to explain how it weighs any particular factor. All that's necessary is that the court consider the factors and explain its opinion so that the public and this court can review it. And here the court did that. It indicated that it
If we said that same analysis applies to Hubbard factors in the common law right of judicial access with its very powerful presumption in favor of disclosure. Do you see a pattern in our cases that we treat it the same way we do 1353 sentencing factor discussions?
Well, the point is that with any time that a district judge is asked to engage in a balancing test, and here we start with the presumption, yes.
No, I don't know that we've actually, this proposition of law you're pronouncing that anytime there's a multi-factor test, we treat them all the same. Our precedent says we don't require to march through things. If there's some generic body of law that says any multi-factor test, good enough for government work is the rule. And I'm asking whether you discern in our precedent, our Hubbard precedent and common law right of judicial access precedent, that same sort of attitude. There's maybe reasons for differences with different legal issues and different statutory, different multi-factor tests.
Well, first, Your Honor, I just want to take issue with the expression you used, good enough for government work, because we in the government try and turn square corners. So I do not accept that analogy. So that said, when you say, what do I discern that in the court's case law in Hubbard and cases since then, there's nothing in those cases to suggest that the traditional rules that apply when judges are asked to apply their discretion in weighing factors is any different for Hubbard than it is in other contexts. If the court now finds that Hubbard is different and that a judge is required to express how it weighs certain factors, then write that opinion and remand to the district court. But our point is that based on the court's case law as a whole, we don't see any requirement for the district court here to do more than explain how it reached the decision it did.
All right. Anything further?
Just one.
Yeah.
I guess I'll ask you this in private too, but just in general on the SEC disclosures, if you assume for the sake of argument that there are judicial records and that some of the materials discussed in the SEC filings overlap with some of the issues addressed in any judicial records that might exist, don't we at least have to remand for the district court to consider the extent to which the SEC filing undercuts the continued basis for keeping any records secret?
If the SEC's pleadings disclosed a substantial amount of the materials that were in the search warrant materials, then that could be a basis for remand. I can't answer the court's question in public session.
Right.
All right. So why don't we hear from counsel for petitioner?
Thank you, Your Honor. And just briefly to respond to a few points made by Ms. Dinello, I think this court's precedent is clear that the district court is obligated to apply the six-factor Hubbard test with specificity to account for all the various private public interests at stake and to set forth its reasoning with sufficient specificity in order for it to be reviewed by this court. Most recently in CNN v. FBI, this court dealt with a district court order that did purport to apply each of the Hubbard factors. This court found reversible error because each of the factors wasn't applied correctly and didn't take into account what this court deemed to be the important additional national security context that was implicated in that case. You can go back to the 1980s to NRA National Broadcasting Company, where this court found reversible error because the district court, though it purported to apply the Hubbard test, did not gave, quote, short shrift to the interest in favor of disclosure in that case. So the notion that this court's existing precedent doesn't support a requirement that the district court apply Hubbard with specificity, I think is unsupported. I want to be clear too that our objections to the district court's order are not mere semantics. They're not just about how the district court authored the opinion because it felt constrained in terms of what it could put into the public record. It is evident from the face of the order that the district court considered interests that may be present in other cases, but are decidedly not present here, including purported stigma to Senator Burr from disclosure of the existence of the DOJ's investigation. At the same time, it is also evident from the face of the order that the district court did not consider interests decidedly present here. I think the district court's reliance on WP2 and its conclusion that that district court decision dictated the results underscores that the district court was doing exactly what the district court said it was doing, which was applying a categorical rule that, quote, no disclosure of search warrant materials would be appropriate in a closed, non-public investigation that has not resulted in criminal charges and where privacy and governmental interests may be implicated, which is effectively any case in which the government has not, quote, acknowledged the existence of the investigation in a seemingly very particular way. So this is not just a semantics issue. It's not a dispute about the district court's reasoning not being fulsome enough. We think it is evident from the opinion itself that the district court applied the wrong standard, which is, as this court has made clear in Leopold and in CNN against FBI, though motions to unseal, decisions to seal and unseal are typically reviewed for abuse of discretion, to the extent the court applied the wrong standard, that is legal error. With that, Your Honors, we would ask if there are no additional questions that the court reverse.
Thank you, counsel. We will continue argument ex parte, and the deputy clerk, please close this argument and advise us when we may proceed with the ex parte argument.
This honorable court is now adjourned until Friday, February 4th at 9:30 a.m.